So, on the 31st of December 2020, the Syiem of Maharam, Maukarwat, sir, had issued a public notice by his letter number MS/ED/20/1347 dated Maukarwat 31st December 2020, wherein he had directed the residents of South Sampair area, comprising of 15 Darbar Shnongs, that in the event of any land transaction by way of sale, 50% of the amount of the land sold or donated to the government should be given to the Syiem. So 50% of that should be given to the Syiem, and 20% of the amount to the owner of the land, 20% to the Darbar Shnong, and 10% to the Darbar Rai. So again, for those category of land that is not inhabited, the Syiem directs that he will get 30%, the Darbar Rai will get 10%, and the Syiem will get 60%. And for those category of land that are beyond the control of the Darbar Shnongs, the Darbar will get 20%, while the Syiem will get 80%. So this order of the Syiem of Maharam is absolutely arbitrary, sir, and contradicting to his own orders issued by his office on the 26th of August 2020. Sir. Sir, I would like to inform this August House that on the 15th of September 1944, the then Syiem of Maharam, Sri Bamun Singh, had signed an agreement with the people of the Rai South Sampair, wherein he had agreed that all matters relating to land in South Sampair regulation area shall be dealt by the Rai South Sampair and no one else. So this tradition has been followed over the last 76 years without any change or any disturbances. Interestingly, the present Syiem brought out an order on the 26th of August 2000 to validate and confirm the agreement signed between the Syemship and the Rai South Sampair way back in 1944. Sir. And he also stated that he honors the agreement signed in 1944 and shall abide by it. So in fact, on the 25th of July 2019, the Khasi Hills District Council had passed an amendment bill to include the Rai South Sampair within the ambit and scope of the Maharam Act in compliance with the agreement of 1944, signed by the elders of the Rai South Sampair, which was duly confirmed by the Syiem of Maharam, where in section 2 it states, I quote, provided that in Rai South Sampair the Act shall apply in matter relating to village administration only and not on land regulation, quote and unquote. So, in this regard, the Khasi Hills District Council has written to the District Council Affairs Department in the government on the 24th of February 24th February 2021, by letter number DC 27/General/21/84/79-2021/144/123, dated Shillong 24th February 2021, clarifying to the government the validity and the status of the agreement of 1944, and thereby urging the government to convey the assent of the Honorable Governor on the Amendment Bill of 2019, which is a very important enactment to maintain the customs and traditions of right Sausampere as agreed in the Agreement of 1944. Therefore, through you, Deputy Speaker, sir, I urge upon the government to kindly take immediate action on this important matter by conveying the approval of the Honorable Governor to the proposed amendment bill and take interim measures to stop the arbitrary collection of the land tax by the Syiem of Maharam so as to avoid any untoward incident and breakdown of law and order in the area. So with these submissions, I resume my seat. Thank you, sir.
Thank you. May I request the Honorable Minister in charge to reply.
Mr. Speaker, sir, before replying to the point mentioned by the Honourable Member from Maharam, Shri Himalaya M. Shangpliang MLA, I would like to bring the genesis of the administration of the Syiem Maharam. First of all, I'm very thankful to Honourable Member for bringing this call attention notice under the Rule 51.1 by Shri Himalaya M. Shangpliang. Sir, the Khasi's Autonomous District Council nomination and election of the Syiem, Deputy Syiem and electors of Syiem Maharam Bill 2006 received assent of the Governor on December 2006. As its name suggests, this Bill now Act provides only for the nomination and election of the Syiem and Deputy Syiem by the electors of Syiem Maharam in accordance with the prevailing customary practice of the Syiem. Their appointment, removal, and terms of office, election, and confirmation of the Lengdo and Mentries, and essential qualification for election as Lengdo or Mentries, the composition of Darbar, Syiem and the Executive Darbar, and disposal of case arising out of dispute and appeals arising out of orders issued in this matter. Section 9 of this Act empowered Executive Darbar to make rules for the day-to-day administration of the Syiem, which should be submitted to the Executive Committee for approval. By the Khasi Autonomous District Council nomination and election of Syiem, Deputy Syiem electors of Syiem Maharam First Amendment Bill 2010, the following amendment was proposed. 1. The omission of the word clan appeared in Section 2.1 after the words Lengdo Nonglang, Lengdo Sakwang, and Lengdo Nongsindre of the Principal Act. 2. The omission of the word either the Lengkhoi clan or appearing in the Section 8.2.1 of the Principal Act. The matter was not conclusively processed and the file was misplaced and was found only after a period of 3 years. By the Khasi's Autonomous District Council nomination on an election of the Syiem, Deputy Syiem and electors of Syiem Maharam, Second Amendment Bill 2014, the following amendment was proposed. 1. The deletion of the first proviso of Section 5 of the Principal Act and addition of another proviso after the second proviso to the Section 5, laying down the cases in respect of which the second proviso shall not apply. 2. The deletion of the word duly recommended / approved by the Syiem clan, appearing in between the word of the Syiem clan to the function and as an active Syiem contained in Section 7.1. The bill was returned for reconsideration by the House as it appeared to have been passed without the consent of the Darbar Syiem, which was against the customary practice. The Executive Committee of Khasi's Autonomous Council, by way of notification date 10 January 2018, ordered the following. 1. The insertion of proviso after subsection 2 of Section 1 of the Principal Act, provided that in right Sausampere, the Act shall apply in matter relating to village administration only and not on land administration. 2. The insertion of proviso after the clause J in Section 2 of the Principal Act, provided in right Sausampere, the mentries shall be also known as Ramba Shno. 3. The insertion of proviso after subsection 3 of Section 8 of Principal Act, provided in right South Sampere, where the vacancy of post of Menteri or headman occurred, it shall be reported to the Syiem and his Darbar with the recommendation from the Darbar right, and the meeting for election shall be presided by the Syiem or by any person authorized by him in the presence of the representative of the Darbar right, who will jointly declare the election result. Further, the term of office of Menteri or headman is fixed for the period of 3 years from the date of issuing of Sanad. The Principal Act thus amended would be called the Khasi Autonomous District Nomination and Election of Syiem, Deputy Syiem and Electors of Syiem Maharam Act 2017, which was to become into force as Executive Committee Khasil's Autonomous Council may, by notification in the official gazette, appoint. By the same notification, the Executive Committee of the Khasil's Autonomous Council ordered the insertion of the proviso after the subsequent Rule 12 of Rule 6 of the Maharam Simship Administration Rules 2009, provided that in the right South Sampere, the Syiem and his Darbar shall recommend the newly created village to the Executive Committee for approval only after the consent of Darbar right. The principal rule thus amended and would be called the Maharam Simship Rules 2017, which were to come into force as the Executive Committee Khasil's Autonomous Council may, by notification in the official gazette, appoint. The said order by Executive Committee was not notified in the official gazette and therefore carried no effect. By the Khasil Autonomous Council, nomination and election of the Syiem, Deputy Syiem and electors of Syiem Maharam, Amendment Bill 2019, the following amendment was proposed. 1. The insertion of proviso after subsection 2 of section 1 of Principal Act, quote, provided that in right South Sampere, the Act shall be applied in matter relating to village administration only and not on land regulation. 2. The insertion of the proviso after clause J of section 2 of Principal Act, provided in South Sampere, the Menteri shall be also known as Ranba Shnong, bracket headman. 4. The insertion of proviso after subsection 3 of section 8 of Principal Act, quote, provided in the right South Sampere, where vacancy of the post of Menteri or headman occurs, it shall be reported to the Syiem and his Darbar with recommendation from Darbar right, and the meeting for election shall be presided by the Syiem or by any person authorized by him in the presence of the representative of the Darbar right, who will jointly declare the election result. Further, the term of Menteri or headman is fixed for a period of 3 years from the date of issuing of Sanad. As none of the amendment bill have received assent of the Governor, the provision of the Principal Act continue to have effect. This fact also holds true for the order passed by the Executive Committee of the Khasil's Autonomous Council by notification dated 10 January 2018. It must be noted that as stated above, the Principal Act and for all proposed amendment to this Act deals only with the nomination and re-election of the Syiem and Deputy Syiem by electors of Syiem Maharam in accordance with the prevailing customary practice of the Hima. Their appointment, renewal, or term of office, election and confirmation of the Lengdo and Menteris, and the essential qualification for election of Lengdo or Menteri. The composition of the Darbar Hima and the Executive Darbar and disposal of case arising out of dispute and appeal arising out of orders issued in this matter. The instant subject matter is beyond the purview of provision of Principal Act and appears to be rather covered by the Maharam Simship Administration Rule, which are met by the Executive Darbar and approved by the Executive Committee as empowered under Section 9 of the Principal Act. The said rules were not present to the Governor for his assent, and the supervision contained thereunder as not in knowledge of the government. The Khasil's Autonomous Council has been requested and its replies in the view of the matter, its view on the matter. However, no communication has been received. In fact, sir, the government of Meghalaya on The issue regarding the agreement of 1944 have written to the Cassius Autonomous Council. The last is on the 15th of February, which I may quote to the Secretary Executive Committee, Cassius Autonomous Council, Shillong. Subject objection to the Khasi Autonomous Council nomination and election of Syiem, Deputy Syiem, and electors of Syiem Maharam Amendment Bill 2019. Sir, I am directed to refer to your letter on the subject cited above and to state that the Cassius Autonomous Council nomination and election of the Syiem, Deputy Syiem, and Syiem Maharam Amendment Bill has not been assented by the Governor. The content of letter number GSMG 225/2019-960-10/9/2019, along with its enclosure as forwarded to you, white or letter number DCA 53-2006-44-17/10/2019 have also been kindly taken to may also kindly be taken into consideration. Further, the agreement of 1944 referred to in your letter cited above may kindly be submitted for placing the bill before the Honorable Coroner for his assent. But I'm very glad that today that the Honorable has mentioned that on 21st of February, this council have written back to the government regarding that information. I have not, it's not there with me. I will duly see to it, and if everything is ordered, the matter will be referred to the coroner's, Mr. Deputy Speaker, sir.
So I'd like to thank the Honourable Minister in charge of District Council Affairs for being very elaborate, and it's very clear now what is the status of this whole matter. Just to inform the Honourable Minister, I have a copy of that letter that has been replied by the District Council. It is dated 24th February 2021. This is in reply to the letter that was sent to the District Council dated 15th February 2021. So the reply has been sent on the 24th of February. May I request the Honourable Minister to kindly take a personal note of this, and we may be conveyed with the assent of the Governor at the earliest. Sir, the concerns of the whole matter relating to the people of South Samper, wherein the Syiem is arbitrarily collecting this money. Therefore, we need to stop that. So therefore, sir, we need the assistance of the government, and the bill clearly mentions, as the Honourable Minister has mentioned, that in section 2, where it is written, provided that in right South Samper, the act shall apply in matter relating to village administration only and not on land regulation. So the Honourable Minister also has a copy of the same copy of the bill, which I also have, and I hope with the reply that the District Council has given to the government, we should be able to proceed immediately to the Honourable Governor and get his assent to protect the interest of the people of South Samper, and also to retain the customs and traditions of the land in right South Samper, sir. Thank you so much.
As already stated, Mr. Deputy Speaker, sir, I've already mentioned that we will go through the reply of the KHADC regarding this bill, and if the bill is improper, we will forward it to Commission for the immediate assent of the Honourable Coroner.
Now we come to item number